from.
Thank you very much, Chairman Roberts, and I sincerely appreciate this time. And as you know, I serve a very rural, very mountainous region, and in the mountains they say if there's a problem, there's a solution. If there's no solution, there's no problem. Well, I think that we all have to concur it's an undeniable fact that our federal government has grown well beyond its specifically enumerated powers. The ever-increasing scope and size of the government not only violates the original intent of our founders, but also threatens to suffocate our liberty through draconian overreach antithetical to principles of federalism. Today, we face a federal government that has taken literally hundreds of thousands of steps beyond the boundaries drawn by the Constitution. In Tennessee, we've taken corrective action in the past by making certain that we would never enforce any Bill of Rights things regarding our Second Amendment should the federal government enact them. And that was a very appropriate and necessary step. But during COVID-19, we saw many attempts at strong overreach of the federal government. And so the opinion on the constitutionality of a national bank, that's one of the first times that we really hear what our founders' opinions was on government overreach. And Thomas Jefferson wrote, "I consider the foundation of the Constitution is laid on this ground, that all powers not delegated to the United States by the Constitution, nor prohibited by the states, are reserved to the states or to the people," and that's the 10th Amendment. To take a single step beyond the boundaries of thus specifically drawn around the powers of Congress is to take possession of a boundless field of power, no longer susceptible to any definition. And that is a quote from Thomas Jefferson. And when you go on in our government, as people have alluded to these abuses of power and have challenged these abuses of power, one of the key things that we can look at is abuse may happen in any government. The only resource against usurpation is the inherent right of the people to prevent its exercise. This is the case of all free governments in the world. The people will resist if the government usurps powers not delegated to it. And in the Federalist number 46, James Madison made the same case, noting that legislative devices and a refusal to cooperate with officers of the Union is necessary when used by multiple states, and it would present obstructions which the federal government would hardly be willing to encounter. And this was, I think, very important during the ratification. Sherman, who was the only person to sign the Continental Association, the Declaration of Independence, the Articles of Confederation, and the Constitution during the Connecticut Ratifying Convention, argued all acts of the Congress not warranted by the Constitution would be void, and such acts be unenforceable without the sense of a majority of the states. He continued, noting, when the federal government overleaps those bounds and interferes with the rights of state governments, they will be powerful enough to check it. And then when you go to Federalist number 16, Hamilton argued, if the interposition of the state legislatures be necessary to give effect to a measure of the Union, they have not only to act, but to act evasively, and then the measure will be defeated. So that's kind of, a lot of people say, oh, no, we can't do nullification. But when we talk about nullification happening today, we generally mean in the practical sense, to end the practical effect of a federal act. The federal government involves itself in almost every aspect of life, but depends on state assistance to do almost everything. And even as the National Governors Association in 2013 stated, the federal government, during the federal government shutdown, states are partners with the federal government in implementing most federal programs. And that goes us down to why this bill. The main purpose of this bill is to end Tennessee's practical participation with federal actions that it finds constitutionally violative. And the support from the Supreme Court in the United States was in the anti-commandeering rulings that they've had several. And the strategy of non-cooperation has not only been proven effective, it's also been repeatedly validated by SCOTUS, with multiple opinions holding that the federal government cannot require states to expend resources or provide personnel to help carry out its programs. So one of the chief cases of that was Justice Scalia in the Prince case, and it serves as the cornerstone. He wrote the opinion for the majority. We held in New York that Congress cannot compel the states to enact or enforce a federal regulatory program. Today, we hold that Congress cannot circumvent that prohibition by conscripting the states' officers directly. The federal government may neither issue directives requiring the states to address particular problems, nor command the states' officers or those of their political subdivisions to administer or enforce a federal regulatory program. It matters not whether policy making is involved, and in no case-by-case weighing of the burdens or benefits is necessary. Such are fundamentally incompatible with our constitutional system of dual sovereignty. And in 2018, the Murphy case, the Supreme Court reaffirmed and even expanded the anti-commandeering doctrine, holding that Congress can't take any action that dictates what a state may and may not do, even when the state actions conflict with federal laws. Samuel Alito wrote, "A more direct affront to state sovereignty is not easy to imagine." He continued, and I think this is very critical here, the anti-commandeering doctrine may sound arcane, but it is simply the expression of a fundamental structured decision incorporated into the Constitution, the decision to withhold from Congress the power to issue orders directly to the states. Conspicuously absent from the list of powers given to Congress is the power to issue direct orders to the governments of the state. The anti-commandeering doctrine simply represents the recognition of this limit on congressional authority. And I will speed this up and just go down to what a determination, if a determination of constitutionality is necessary. It's important to understand that no determination of constitutionality is necessary to invoke the anti-commandeering doctrine. State and local governments can refuse to enforce federal laws or implement federal programs, whether they are constitutional or not. The crux of the anti-commandeering doctrine is that a state has the right to direct its personnel and its resources as it sees fit. We are elected to represent the people of Tennessee. It can prohibit the enforcement of federal laws or the implementation of federal programs for any reason at all. The state could withdraw state resources from enforcement of a federal act just because it's Wednesday and it's rainy outside. So what we're looking at now, we did correct action with our gun laws. We did that to protect us if the state would ever try to violate our Second Amendment, and that is right and just. But right now, when we're looking at what determination shall be made in the form of a bill which shall require an affirmative vote of a majority of the members to each house, the bill shall be presented to the governor before it takes effect. That's what part of our bill said earlier. We have put an amendment on the bill, and the summary of the bill as amended requires the Government Operations Committee of the House of Representatives and Senate to monitor and review federal acts, laws, orders, and regulations that may impact the jurisdiction, governance, and sovereignty of the state of Tennessee, and advise the General Assembly of any findings before December 15th of each year. It requires the General Assembly to consider the constitutionality of such act, law, order, or regulation. And it authorizes the General Assembly to direct the Attorney General and reporter to file a lawsuit challenging the constitutionality of such act, law, order, or regulation. But I would repeat, from the anti-commandeering laws, we actually do not have to enforce those. But if we want to challenge it, we can challenge it. We can challenge it by not enforcing it, and that is allowed according to our constitutional mandates.